much, Carrie. Great to be here today with you guys to talk to you about this very important topic, choosing the right executor for your estate. We are going to, I'm going to do my best to try to get to some of the questions that were submitted in advance, and we'll have a Q&A at the end, and we will be able to tell you a little bit about ClearEstate as well. So for starters, who am I? Why am I presenting to you on this topic? So I've been in the estate and trust industry for many years and have worked both on the estate planning and the estate settlement side of things. And my goal is always to help make things a little bit more approachable for folks as we talk about these sometimes technical but highly personal matters. A little bit about ClearEstate. Essentially, ClearEstate is a modern trust office, if you will. Our goal is to bring our tech-enabled solutions to the masses and allow more people with simple and easy professional services in the estate and trust space. And we do use technology to help us do our processes more efficiently and help it make things easier on the families that we support. The goal really here today is to help you to confidently choose the right executor for your situation. Now, I'm going to start by prefacing the conversation with something that maybe many of you know, but maybe if you don't, is that estate settlements really can be complex and time-consuming. There's lots of different components involved. There's logistical and practical matters. There's legal matters. There's, family dynamics to deal with, which even in the best of scenarios are not always easy to navigate. The role of executor is a fiduciary one, and it's typically lots of different third parties you're dealing with, lots of different forms, and often hundreds of hours of support, and you're dealing with different professionals along the way. I think when it comes down to it, the role of an executor is really, so this is the person that you appoint in your will to actually take charge of your estate, to be responsible for the settling of your estate. That can include a lot of different things, but ultimately they're accountable to complete all the necessary steps to administer your estate and distribute the assets to the rightful beneficiaries, typically making decisions along the way, depending on the assets, the tax situation, and that they always have the best interest of the estate and all its beneficiaries in mind as they do their work. Now, the executor, when I say a fiduciary role, what that means is essentially you have a legal obligation to act in the best interest of others, and that you're personally liable for any breach of this duty. And breaches can happen for a number of reasons. Sometimes because someone is intentionally acting in a way that they shouldn't, or sometimes because someone unintentionally is acting in a way that they shouldn't. Now, they have the power to, depending on the terms of the will and the applicable legislation in your jurisdiction, they have the power to sell estate assets such as a house or investment portfolio. Of course, they have the power to pay bills and liabilities. They should assess whether those are just debts and liabilities. And they have the power to access the deceased financial records and personal information, and of course, make decisions with respect to the estate settlement. Now, like I'm not going to necessarily list all the detailed work that an executor might do. Needless to say, I think it depends on the estate that they're tasked with settling, how complex the assets are, how complex the probate process might be, and how complex the family dynamics are as well. But ultimately, the executor is responsible for preserving and protecting the assets of the estate until they can be distributed, for creating an inventory of the assets and liabilities of the estate as of the date of death value of the assets, and applying to court for probate if probate is needed. Probate is typically needed whenever the executor has to deal with third parties like banks in order to access the deceased accounts. And the probate process is typically a bit of a challenging one because it takes time. There's a lot of legal sort of paperwork involved. And the executor is sort of attesting to the information they're submitting in that probate application. So it's very important that they're doing that accurately to the best of their abilities. They're responsible for preparing and filing any tax returns that are required. Typically, there's the tax returns that are required as a result of your passing, but then there's also, if any prior year's tax returns were not filed, they're responsible for that as well. Of course, they're responsible for paying debts, taxes, any expenses related to the estate, like funeral expenses or other expenses necessary, like professionals that are involved in it. They're responsible to communicate with the government, financial institutions, service providers, any other third parties that they need to contact to advise of your passing and deal with whatever happens next, which is whether it's cancellations or transferring of rewards points or, dealing with bank accounts and settling those accounts. They're also responsible to account to the beneficiaries of the estate. So essentially, they're responsible to track their activities and transactions and provide an accounting of that to the beneficiaries. Ultimately, the final sort of stages is they're responsible to distribute the estate to the beneficiaries as per the will, if there is a will, or as per legislation, if there is no will. One thing they're not responsible for that some people ask is that they get to decide like who gets what. That's not really the role of the executor. Who gets what is determined by the instructions in your will, as well as applicable legislation if there is not a will. There's a nuance to personal effects that I'll talk about in a minute, but the ideal estate executor is, of course, someone that's trustworthy and responsible. I think that's a relatively obvious one, and a very important one, should not be overlooked. You obviously want someone that you trust to act in this role and that you know is responsible. You want the person to be able to act impartially and exercise good judgment. Impartial is sometimes tricky with family members. We'll talk about that a little bit more. You want them to be younger than you, ideally, because of course, as nature runs its course, naturally, someone younger than you is more likely to survive you and therefore be available to act as your executor. You do also want them to be in good health as well, so that's a consideration. You don't want a minor because if you're not of legal age of majority, you can't actually sign documentation and take on a role like executor. Ideally, the person is somewhat local to you, preferably in the same country. There's differences as to why it becomes a challenge when the person is not in your jurisdiction. One could be practical and logistical. There's a lot of hands-on work to do. How is that going to be carried out? Not that it can't be someone outside just for that reason, but you'd have to think through, okay, what needs to happen? What's going to happen with sort of all of my physical stuff, right? And who's going to actually take charge of it? But further than that, there becomes complications where if the person is outside your jurisdiction, and here I'm thinking particularly outside of the country, then there does become some complications because in most jurisdictions, when you go to file probate, a bond is required. A bond, basically, the way the court looks at it is, they can't be certain that there's no protection if a foreign executor or an abroad executor goes to settle an estate and they act improperly, and there's no recourse for the beneficiaries because they're not in the country. So the court takes that very seriously, and they'll require a bond, which means that your loved one would have to get a third party bond, a bond to basically assure the court that they would that they would basically secure that they will act as they should in the estate settlement, and that bond could be set at the entire value of the estate, and it can be very expensive and can be a lengthy process to obtain. So this is one major reason, but actually another one is there could be potential tax complications as well, because an estate is considered to be resident of whatever jurisdiction it's managed from, which means if you have a foreign executor, you could unintentionally make your estate a subject to taxation in two jurisdictions. It may have a significant impact, it may not, but these are the complications that arise. And so it's generally recommended that your executor is located in the same country as you. The other things are, of course, you want them to be comfortable navigating legal, tax, and financial matters. It typically is going to be a lot of discussion and things that they have to deal with that are going to be new to them. They're not going to be familiar with it. At least I hope they're not, because if they're familiar with it, that means they've dealt with state settlements before. And typically most people maybe have one or two that they've dealt with in their lifetime. Now, you need them to be patient and detail-oriented for sure, particularly when you're submitting forms. They all have to be, filled out properly. Probate applications are actually commonly rejected for very minute, little clerical type of details. So it's really important that they're patient, detail-oriented. Also, that they're a good communicator, that they're comfortable and confident with relaying messages to the other parties that are involved in the estate settlement. And that they're able to face challenges and maybe some adversity, because generally speaking, most estates come with at least some type of hiccups along the way that the executor will need to navigate. And of course, you want them to understand the role. Like, they need to know what they're kind of getting themselves into, and they need to agree to it. And unfortunately, I think most folks not only do they not actually understand the role, but a lot of times they actually don't even know they're appointed until after someone has passed away. And that's really not an ideal way to go about it. You really want the executor to understand what's involved and be prepared to act in that capacity. Some highlights of what to avoid, which kind of ties back into the ideal executor, is you want to think about, is this person, do they have like a really busy life, a career, family? Like, do they run a business? Do they have, young children? If they're not going to be able to sort of drop what they're doing and kind of focus on the estate settlement, that may actually be a challenge for them personally and in your estate settlement as well. I already talked about those who live abroad and the reasons why. Definitely anyone that you are worried may become overwhelmed by it. I would think in particular, because at the time they're also grieving, potentially they've just lost a loved one. So it may be, emotions may be kind of strained already. And so if you feel like it may be overwhelming to them, and I can tell you as someone who's been through it myself and also knows how to deal with these things, it was overwhelming for even me. So I think it's something that we should think about carefully. Definitely, you want to avoid anyone who you feel like will not be able to manage the family dynamics that are in play, or any conflict that might arise, or even, maybe they're going to contribute to it themselves in some way. And usually we kind of have a sense of what might kind of people might, what conflict might arise over, but sometimes you'd be surprised. So I think it's important to kind of think about that part carefully, not just what you expect, but also what you might not be thinking of. And of course, anyone who may have a conflict of interest, this is a tricky one, because typically people, when they appoint a family member, they're appointing someone who's also a beneficiary of their estate, which technically automatically means like you're asking them to kind of wear two hats. They're a beneficiary and they're an executor. Those roles and sort of rights and responsibilities are a bit different. So I think we want to think through carefully whether or not, there is any real or perceived conflict of interest amongst family members in an estate settlement. Certainly, you do want to choose those who you don't want to choose someone who's not really able to manage their own finances, because that's generally an indicator that this may be too much for them. And in some cases, for example, if a bond is required, which the court reserves the right to require a bond in any case. If a bond is required and they don't have a great financial situation, it will be difficult for them to secure that bond. The other thing is co-executors. This is a topic that I think folks think about a lot. Should I appoint, one child, both children, my two friends, just one friend? And I think it's important to think about, there's pros and cons to this. If you point co-executors, you're now you have a team and there's room for discussion around decision making. Sometimes that can be a good thing, but sometimes that can be a bad thing. If it's likely they're not going to see eye to eye, if they, if you don't think they're going to agree on how to proceed in certain cases. I mean, we don't necessarily know for sure, but if you're not confident that they're going to be able to discuss and agree upon things, then I don't necessarily think it's a good idea to have those folks as co-executors, because when you're co-executors, you all have to agree on everything. Everyone has to participate in the decision making. Everyone has to sign off on those decisions. And the other thing is sometimes too many co-executors. In addition to the problems I just mentioned with decision making, if there's too many co-executors, like now you're adding more opinions into the mix, but you're also adding more steps into the process, where forms have to be signed, probate applications has to be signed, it has to be dealt with all these multiple parties, and there's more convenient ways of doing that now than there was once upon a time, but still adding all the parties and requiring them to sign everything it can delay things. Now, let's talk a little bit about appointing family members or friends versus appointing a professional. And I'm going to preface this by saying, there's no real right or wrong way of doing things. There's no hard, fast rule of how you should do things. It's really about what is right for you and your family, right? And you know that best. And I will say one of the major pros of appointing family or friends is obviously there's a personal connection to you, right? They know you personally. If you're considering this person in this role, they probably know you very well, and they will have a sort of moral. They'll feel a moral duty to carry out your wishes. That can also be a bad thing sometimes, because sometimes folks will feel obligated to carry out the role when in fact, they're not comfortable doing it, or they, will become in over their head, right? But nevertheless, obviously, someone personal to you, that's a significant aspect of considering a family or friend. But I'll say, based on everything I've said so far, estate settlements and the responsibility of an executor, it's a big one, and it's one that I think, the more people start to understand what's involved in settling an estate, the less likely they're actually to want to take on that role, right? And that's fair, because we're talking about hundreds of hours of work over, a course of 16 to 24 months, and an actual liability that technically never goes away. Even if you've completed the estate settlement completely, distributed everything, accounted, everything's done, something crops up in future, you still have to deal with that. And so that liability kind of never truly goes away. Typically, a friend or family member is not familiar with estate matters unless perhaps maybe they work in that field. And and there's no certainty that they'll be able to act. And by that, I mean, will they survive you? Will they be, still healthy to be able to do it? Will they want to do it when the time comes? There's not as much certainty around that when you're appointing an individual. Often, I mentioned this already, it's difficult for them to be truly neutral because, of course, there's always going to be some form of, because of that personal connection, they have knowledge that is it makes it difficult to be neutral potentially. And even if they do manage to be impartial, they may still not be perceived that way because they're, your daughter or your, sister or because they have that relationship already, because there's already family dynamics at play. It can lead to strained relationships for sure. Unfortunately, this happens a lot in families. Estate settlements can be challenging even in the simplest of circumstances, and often can lead to strain in amongst family member relationships, especially where there's a family member that now is accountable to report their activities to other family members. And it, I'm sure you can guess that sometimes that can lead to strain in family relationships. They probably won't be able to manage complexities, and they typically will need to engage professionals in the estate settlement at a cost to your estate that you won't know, and you won't have any real say in if you haven't kind of planned for this. So these are all important things to keep in mind. And of course, they're going to be grieving and potentially overwhelmed. Now, on the flip side of that, a professional executor can be a good option because, while they have no personal connection to you, you're able to have an experienced, neutral, third party that's going to be able to kind of take charge of things and guide everyone and explain to everyone what has to happen, alleviating the burden on your loved ones completely. They will, be able to act neutrally and impartially. They're held to an even higher standard, than a lay executor would be in terms of their, duty to act prudently. And there's going to be no impression of favoritism. There's going to be no, potential. It's going to help to ensure that, your estate settlement doesn't contribute to strain in family relationships. And of course, professionals can typically handle varying degrees of complexities. And of course, there's not the emotional side of things that they're dealing with. So I'm going to talk about a couple of specific case examples of some estate settlements, just to kind of illustrate what we're sort of talking about when we say what can kind of go wrong based on the executor that you've chosen. So I'm going to talk about Vivian. Now, Vivian has 3 children and they get along pretty well. She appoints them all as her executors. So they're going to act, the 3 of them, as co-executors. Now, when Vivian passes away, though, her children all are grieving and they're sort of reacting differently to the news that they're being appointed as executor. In this case, they hadn't talked about it in advance. They weren't aware that they were appointed in this capacity. And they hadn't really put any thought into what would be involved. So Vivian's son, Ron, he takes charge and begins executor work immediately. He starts to, of course, make the funeral arrangements, starts to collect information about the assets, starts to cancel things. Meanwhile, Jennifer is really busy. She has a busy career and a busy family life, but she does want to participate, and she doesn't really want Ron to be doing too much without her. Now, Henry, on the other hand, is having a really hard time processing the loss of his mom. And as a result, he's sort of shutting down and he just can't really bring himself to participate. Now, as you can imagine, what that means is that, they can't really all come together. They're all in different places. They're all in different headspaces. And they're just not really able to coordinate on how to proceed and how to move forward. So things in the estate settlement obviously stall because as much as Ron can go ahead and run around doing things, remember, he needs his siblings' signatures because they're all 3 co-executors. So there's a limit to what he can actually push forward. Now, ultimately, Ron and Jennifer kind of can figure out can coordinate themselves, and they do want to be sensitive to Henry, but they are motivated to complete the process. And it's not necessarily because, they want to settle the money. It's because most folks often want to get through the process so they can feel some sense of closure in the matters. Now, because Henry is not really willing to participate, they can't get him to sign things and move forward. And he won't agree to resign his role, which is an option. He can resign and not continue acting as an executor. They have to get a court order to remove him as an executor, which means they have to go through a court process where they're explaining, what's happening and why they need to remove him. And then the court has the final say on what happens with that. Now, this obviously means additional time, legal costs, and significant strain in the family relationships. I think it's important to select your executors thoughtfully and ensure they understand the role and that they're prepared to carry it out. I think, Vivian could have really discussed this with all of them. And maybe they could have let her know. Maybe Henry would have had an inkling that, this was not really something he was going to be prepared to deal with. And maybe Vivian could have adjusted her executor appointment based on that. Or maybe Vivian could have thought it through and knowing her children's personalities could have based it more on that. I think what Vivian was trying to do was treat them all equally by appointing them as co-executors. But you can see the end result is probably not what she intended. They, of course, could have also considered a professional executor to alleviate that burden as well. Now, Dawn and Mary. So in Dawn and Mary's case, they have two daughters. Sandy, she's a mom of two. She's a graphic designer. She has a busy professional and personal life. And then Leah, who has a disability, and she lives with Dawn and Mary, and they make sure that all of her needs are met on an ongoing basis. They have appointed Sandy as their executor, and they have done some estate planning. So they have thought through Leah's circumstances and incorporated estate planning using a Henson trust so that Leah can have a trust for her lifetime that's going to provide for her, but also protect her access to government programs and benefits. It's a common strategy that's used in cases where any of the beneficiaries would have access to a disability tax credit certificate. Now, what happens is when Dawn and Mary have both passed away, Sandy has to determine new living arrangements and a care plan for Leah to meet her needs, because ultimately the plan is to sell the home and move Leah into accommodation where she's going to have the care that she needs. Dawn and Mary did do a little bit of planning for this, but it's still up to Sandy to kind of finalize things, make sure that things do make sense, and kind of Leah's immediate needs she has to scramble to address. She's also going to act as executor for the estate. And once all that work is done, the trust is going to be set up for Leah, and she's the trustee of that trust on an ongoing basis. And that trust is for Leah's lifetime. So she has responsibilities, basically, in perpetuity, right? Now, obviously, she's also going to continue to advocate and care for Leah's needs. Now, when you put all that together, this is really a lot of responsibility, especially when it's kind of all happening at one time. So Sandy, ultimately, she's completely overwhelmed with dealing with all these new responsibilities, and she doesn't really know how to do any of them. So I think it's important to think through the practical challenges your executor is going to actually face in your estate settlement. Where there's personal care needs, involved, like this can actually be a significant burden on someone to try to figure out and navigate, right? So it's not always easy to fulfill these responsibilities. They certainly could have considered a professional executor and trustee in this case, because a professional would be able to also manage the trust on an ongoing basis. There's there's duties that are required, including, keeping a proper accounting, and filing tax returns annually. The other thing that I didn't put on the slide, but is a nuance that happens often, because often it is the same person that ends up kind of carrying out all these roles. If the person has the type of disability where they actually need somebody to formally be their guardian for property and for personal care, technically there is a conflict of interest between acting as, in this case, Leah's guardian for property, and also acting as the trustee of the trust, because basically the guardian for property, it may ask the trustee for funds from the trust, and then the trustee decides whether or not to release funds from the trust, and if it's appropriate to do so. And so it's a built-in conflict of interest that sometimes is hard to deal with when there hasn't been adequate planning in advance. Okay, the third case study I'm going to talk about is Helen. Now, Helen has 4 children and 10 grandchildren. They all get along. They enjoy family gatherings. Everyone shows up for their reunion. There's no conflict or controversy. And Helen has appointed her eldest daughter, Quinn, to act as the executor of her estate. Her will provides legacy gifts for her grandchildren. Legacy gifts are specific gifts, a cash amount or a specific item, in this case, $10,000 each to her grandchildren. And then the balance of her estate is going to be split between her 4 children per stirpes. Per stirpes means by bloodline. So if a beneficiary predeceased Helen, then their children will receive in their place. There's no specific mention of personal effects. And in fact, one of Helen's children, Tobin, he does end up predeceasing Helen. Now, in the estate settlement, there's 2 significant problems that arise. One is strain amongst the grandchildren, because Tobin's children are actually receiving more than them, because they're receiving their $10,000 legacy gifts. And they're also receiving their father's share, Tobin's share of the estate. So the grandchildren don't really understand that. And Quinn doesn't necessarily do a great, have the right kind of words or means of communication to explain these matters to them. Now, the other issue is that she faces significant difficulty dealing with the personal effects. Some of them are valuable. Some of them have significant sentimental value, and everyone has a different opinion as to what should happen with them. And without any specific instructions in the will, the residual distribution, you'll remember, is equally to the 4 children, which means technically the personal effects also need to be divided equally between the 4 children. Now, that's easy to do with a cash amount. It's not so easy to do with a house full of things, right? And so in these cases, it becomes difficult. The sort of defaults could be, the only way to make it fair is like sell everything and then divide the cash. Is that really what family members want? Probably not, right? But how do you ensure that they're all receiving equally from personal effects? It's very difficult to do that. So I think the result is family members are angry with each other. They're taking sides, they're fighting, and Quinn is not really able to handle it. She's not the type to kind of be forceful in her communications, and it becomes quite a difficult situation. So I think it's important to set your executor up for success. First of all, by choosing the right one, someone who you know will be up for the task of navigating family dynamics. Remember, like I said, even if you don't think there's going to be any issues, and communicating the right messages. Secondly, providing clear instructions for the distribution of your assets is so important. Oftentimes, personal effects are overlooked in estate planning, and meanwhile, they are the things that actually cause the most conflict in families. So certainly Helen could have considered a professional trustee, and in addition to doing some planning around what she actually wanted to have happen with those personal effects. So I'm going to talk quickly about some of the professional options out there available to you. You could potentially engage a lawyer. Not all lawyers will agree to act as executor, but the ones who do, they're going to be impartial, they're going to have legal expertise, they're going to be able to deal with complex matters, and in some cases, even litigation, although litigation is a real specialty, so oftentimes even a lawyer would refer to a specialist lawyer to deal with litigation. The cons, I would say, typically they're not necessarily in a rush to do the work. It's sort of added to the pile on their desk, and it's often not the only area that they practice in. Their main area of practice is often another area of practice. They do, if they act in this capacity, they are appointed in their personal name in your will, and they're actually entitled to take full executor compensation. In Ontario, for example, the guideline for executor compensation is 5% of the date of death value of the estate assets. And they actually can also charge legal fees on top of that for preparing the probate application or giving legal advice or anything that they've billed through their law firm as well. They do tend to focus mostly on legal aspects, although some will help with the more administrative details. And certainly if they're acting as an executor, they should. They would typically outsource tax matters, and often their communications and their sort of bedside manner can be very formal. And this may or may not be comfortable for your family. Financial advisors and accountants similarly can be appointed in their personal name in your will. It's not common that financial advisors, accountants, and other types of consultants might do this work. But if they do, they would typically be able to be impartial. I put typically because sometimes there's a conflict with financial advisors because they're also managing your assets. So there's a potential conflict there. And in fact, regulators are looking more and more at limiting a financial advisor's ability to potentially act in this role. But generally speaking, this is probably someone you trust. You probably worked with them closely. The cons, I would say, they will need to hire other professionals. They're typically not very experienced in estate settlement, even if they agree to do it. A lot of them agree to do it reluctantly. And they also may charge full executor compensation on top of engaging other professionals. Trust companies, of course, this is, I think, the professional we typically all associate with acting as an executor. They will act impartially. The use of a trust license allows for continuity. By that, I mean a company that holds a trust license is the only type of company that can be appointed in a will. So when you're appointing a company, you're guaranteeing that there'll always be an employee to step into that place, rather than with a lawyer where you're appointing them as an individual. They certainly would have expertise and resources. Most trust companies have been around a significant amount of time. The ones that operate in the space are certainly experts. They do have lower fees available for high net worth clients. However, on the con side, generally their fees are inaccessible for most families. They offer blended rates, so depending on the value of your assets, there's a sort of sliding scale of fees. But generally, it starts at around 4 to 4.5% for the first million, and the minimums are between 15,000 to 30,000. So it's very difficult for most families to even consider this. I would also say a con is that technology is underutilized. They don't necessarily embrace technology to do their work more efficiently. So you're still kind of stuck with potentially a long process and maybe not the transparency that you might hope for. So limited visibility for your family. Just to talk a little bit about Clear Estate and how we do things here, we do offer a professional executor plan, of course, to alleviate the burden from your family. Because we use our platform to do the planning side of things with you and actually make sure that we have everything that we need to carry out our work when the time comes. There's a lot of ease and efficiency that we create for your loved ones. And there's automatic visibility for them because they'll, when that time comes, have access to the platform to see the information that's relevant to them. We also offer the continuity of a professional trust office. I'll talk about that more in a sec. And we are experts in estate planning and settlement. We actually have a super diverse team of experts from the legal field, from trust companies, accountants, and we're essentially a one-stop shop. So we're able to do probate applications, tax filings, all of that in-house, rather than having to engage different professionals for different pieces. And we're affordable and accessible. Our fee for professional executor services at settlement is 1%. Of course, independent and impartial, like professionals would be, and we can address advanced needs, and of course, ultimately help you accomplish the legacy that you intend. I will talk a little bit about how we actually do this. I mentioned that only trust license holders can be appointed as a company. The way that Clear Estate does this is we use a fiduciary partner to be appointed in the document along with us as agent to carry out the burden of the estate settlement. So essentially, we do all of the work, but we still secure a company or a fiduciary partner to act in the will, and that's all part of the same pricing that we include, and I'll show you that right here. Because I know this was specifically asked in advance, and I imagine some people might be wondering. So in terms of our estate planning services, we offer a few different packages just based on what exactly it is you'd like support with, and how complex your situation is. The Essential Plan is really meant to just organize your affairs in our digital vaults, making it easier for your loved ones when the time comes. And our Plus Plan is where you actually want to create a will, power of attorney documents, and your situation is relatively straightforward. Complete Plan is where we start to deal with more complex needs and advanced strategies. And then our Executor Plan is where we actually are providing the professional in your will, optionally in your power of attorney document as well. So the setup fees are what you pay for us to create the plan and generate the documents and have that all done. And then if we're providing the fiduciary, then when the time comes, it would be 1% of the value of your estate. And if you also wanted us to provide the fiduciary for your power of attorney for property, so if you were to become incapacitated, it would be 1% only in the event that it was actually needed. And then if there's ongoing trust to manage, then we would charge 0.75% annually to manage those trusts on an ongoing basis. And we have a lot of flexibility to potentially, either work with a prudent wealth manager or can potentially continue to work with your existing wealth manager if that's what you prefer. And perhaps most importantly, all CARP members receive a 10% discount on any planning or estate settlement package. A little bit about how we actually go through the process of estate planning. Everyone gets a dedicated estate professional, so someone that coaches you through the process. And that person is going to do a bit of intake with you to understand your circumstances, your assets, details about your family, any specific needs and goals you might have, and then provide you with guidance around some of the key decisions, the different components of your estate plan, and what is of particular importance to you. And then you're going to create your documents, execute your documents, and securely store all of your information in our platform. And then you have annual reviews to make sure things still make good sense if they're required, and can make changes to the documents, etc. And then ultimately, when that time comes, there is a sort of transition to settlement that is hopefully as painless as possible for your family members. We do have testimonials available on Trustpilot, so lots of people like to see what other people are saying about us. So definitely something you can consider. And we're going to move to Q&A. I'll just mention we do offer free consultations. You can speak to one of our estate solutions advisors to talk a little bit more about your own circumstances and any questions you might have, as well as talk about how you can be set up with our services. So happy to have you visit the website to be able to do that. And I think with that, we will move on to address any questions that we might have had.
Yep. Thank you so much for that, Sarah. That was great, really informative. We did receive a number of questions, so I'm just going to start off the top here. We talked a lot about family dynamics, so there is a particular scenario that someone has asked about. So I'll just read that now. My uncle and aunt would like me to be their executor. They both have been married twice and have children from their first marriages, and my uncle has a stepchild. They're concerned there will be fighting between children on each side over certain possessions, and one child has been left out of the will. Should I avoid being executor if I know that there could be so much potential conflict?
I mean, I have to say yes. I'm worried about the conflict. Like, this is, even in the best of scenarios, it's difficult to manage, through an estate settlement. And I always say, like, if you manage to emerge in the end and everybody is still speaking to one another, you've done a good thing. Where you already know that there's potential conflict and there's tensions, certainly blended family situations adds to that. And particularly if, the planning is not, sometimes it's adequate for the situation, sometimes it's not. So I think, that I would be very wary as well of taking on that role. Now, no one can be forced to act as an executor. So apart from perhaps a professional, but no individual can be forced to act as an executor unless you start the role. And once you start, you're saying you're agreeing to it. But prior to that, you can't be forced. So whether you tell them now that, perhaps you're not the best person for the role, or you decide later that you won't do it, which is obviously not preferable because then it will leave the estate without an executor, but you can't be forced to do it.
Great. And that actually really relates to the second question we got was, is it possible for an executor, as a family member, to then appoint a professional executor after the fact? So
yes, great question.
Yeah, consider that.
Yes, it is possible. And another thing I meant to mention that I forgot that this reminds me of is oftentimes you can actually appoint a family member and a professional, which lots of people find is sort of the best case scenario, because then you have the personal connection and you also have the professional executor to kind of lead the way as well. An individual can engage a professional. The only thing I'll caution about allowing them basically you're leaving it up to them to decide. And the risk there is that they won't appreciate the value of the professional executor because they don't really, understand what it is for getting themselves into. And so I would say that with caution, that maybe consider appointing both together rather than leaving it up to the family member completely and risking that they won't engage the right professional or a professional at all.
Right. And here's another interesting question we got. If there are beneficiaries outside the country of the deceased, is it beneficial or necessary to have a co-executor in the other country where the beneficiaries reside?
So I would say no, because we're still back to that issue of, are they going to require a bond? Is there going to be tax complications for your estate? What I would say about executors, beneficiaries that live abroad is that, there may be tax implications to them in their own jurisdiction that they should seek advice about from someone who's qualified to provide them with advice on. Generally speaking, in Canada, there's no sort of gift or there's no inheritance tax. There's tax that your estate is liable for that comes out of your estate before it goes to beneficiaries. And then the beneficiaries are sort of getting the after tax, dollars. However, when it's a foreign beneficiary, there is sometimes a withholding tax, depending on the jurisdiction and if there's a tax treaty in place. But generally speaking, it's not going to do anything but complicate your estate further if you have a co-executor abroad.
Great, thanks for that. Here's another question. Is there any way to ensure that your executor actually follows or honors your wishes?
Such a great question. I mean, certain things are, they're legally obligated to carry out their duties, act prudently, do the distributions as you've outlined them. That's not, in any way, shape, or form a decision they can make. They must do that. The recourse would be if they failed to do that. Let's say, they said, actually, I don't like my brother. I'm not going to give him his share. I'm just going to give it to myself. That there would be recourse in the court, right? And there's serious fines and potentially penalties for breach of fiduciary duty. So, there's recourse for that. The way, I guess, there's no way to guarantee it because, people may act inappropriately. It's always possible. The best guard against that, of course, is to choose your executor wisely. I think I've mentioned enough, probably maybe consider a professional. That certainly helps. They're held to an even higher standard and, would be neutral in the estate settlement, but it's difficult to guarantee it in any way, shape, or form.
Great. Another question here. Our lawyer currently is our executor, but he's in his 70s. If unable, it will be our son. Is this okay?
Yeah, great question. Is it okay? It's really a personal choice, right? What's better for you and your family, without knowing any other details about it. I would definitely say, as someone is aging, it's hard to it's hard to not think that maybe it's time to think about even removing them, because one of the challenges that also happens that people don't think of is what if they actually become unhealthy or pass away while they're administering your estate? So lots of people are thinking, something might happen to them before I die. But what actually happens if they pass away or get sick after you've passed away and while they're in the middle of administering your estate? So, I would say maybe think about that and think about what your other options are. Whether your son is appropriate to act or not. That depends on a lot of factors, including, who are the beneficiaries of the estate and whether he's kind of going to be up for the task. And based on everything we talked about today, I hope that gave you some insights as well.
Great, thanks. And to wrap things up, we've only got a few minutes left. We did get a number of questions specifically about Clear Estate and our services. So, for example, and this relates to what we talked about a few minutes ago, can my executor hire Clear Estate after the fact of my death if they feel overwhelmed? So that's the first question. And then after that, there's actually a couple of questions about our fees and whatnot. I'm not sure if you're able to bring up that last slide, if you want, Sarah, but we can maybe go through that. A few people looking for a bit more clarification.
Yeah, sure. So yeah, you can hire Clear Estate in an estate settlement. Sorry, just am I pulling up the right thing? Can you see my screen? Okay, perfect. So yeah, you can hire a professional. An executor can engage whatever professionals they feels appropriate. Sometimes they hire a lawyer, sometimes they hire a trust company. They can certainly consider Clear Estate. Similar I don't have a slide for our estate settlement packages, but similar to our estate planning packages, we offer estate settlement packages for executors who are going through the role and want help and support with that. Similar to our planning packages, they vary based on the level of complexity and the amount of support that's desired. They're also available on our website, so you can see the different packages there. So yes, it's possible for an executor to engage a professional, but like I said earlier, when and how they do that, and whether maybe they've already kind of gone down a certain path that can't be rectified, that's a risk. And sorry, Carrie, what was the other question?
So a couple other questions about our fees and the percentages charged. So one of them was, explain the annual fee for Clear Estate as professional executor. So is this from the time of the nomination, or is it from the time of death until executing the wills? If you could explain that.
Yeah, sorry. For sure. I think I didn't mention that in the initial piece. So the annual fee is for the ongoing access to, the setup fee is for the creation of your plan, the generation of your documents, the work that you're doing together with your estate professional. And then the annual fee is the ongoing access to the platform, the ability to have review meetings, make changes to the documents with guidance, and until you pass away ultimately, or no longer wish to have our services. And then the at settlement is what is charged for after you pass away, when we're going to act in your estate settlement. And there is another mention of annual fees, so I just want to make sure I'm clear. There's annual fees in the estate settlement only if there's a testamentary trust that's ongoing that we're also going to manage. So that's for where you've created a trust in your will, and there's provisions for it to go on for an extended period of time.
Okay, and one more about about the fees, or the percentages. Does Clear Estate receive 5% of the estate value in addition to our fees?
No, in addition to our fees?
I believe our 1% that we charge.
No. So that's a great question. So 5% is the court's guideline. Every jurisdiction is different, but generally speaking, it's approximately 5% or somewhere around 5%. Ontario, for example, it's 2.5% of everything that goes into the estate and 2.5% of everything that goes out of the estate. That's the guideline for executor compensation, whether that's a professional or an individual. So if you appoint your friend, they're entitled to charge 5% of the value of the estate. They could actually charge more than that if they can justify that there's a valid reason for them to charge more than that. And what Clear Estate charges is only this, what I've described here. We don't charge anything in addition to what is listed here.
Fantastic. I think we are just about out of time now. So I'm going to thank everyone for joining us here today. And thank you, Sarah, for all this great information. That was so informative. Everyone, remember, we did record this video. And otherwise, again, thank you for joining us, and enjoy the rest of your day.
Thank you. Bye.